Welcome to Contract Remedies. Sponsored by LA Law Institute, home of free educational resources and more.
Hello all. Have you ever seen a contract exam where the call of the question asks what are the non-breaching parties' rights and remedies? What they are actually asking for is what are the legal rights and equitable remedies. Remedies are a form of compensation or resolution when there has been a breach of a contract. In this video, there are 3 areas of remedies that we will cover, which are legal, equitable and quasi-contract. You will find a few that cross over between legal and equitable, so we will point those out as they occur. So let's start first with available legal remedies. When we talk about legal remedies in contracts, we are always talking about damages, which, as you know, is money. First up is liquidated damages. In some contracts, there will be a clause that spells out what the money damages will be in the event of a breach. The amount is required to be a reasonable forecast of the damages while at the same time being difficult to ascertain. If these 2 elements are not met, the courts may consider the amount punitive and disallow the clause. In cases where there is a valid liquidated damages clause, that will be the only remedy that the non-breaching party will have. A rule that can be found in many areas of remedies is the requirement that steps must be taken to avoid the damage from a breach getting worse. This is called the avoidable consequence rule. Not mitigating after being made aware of the breach will result in a failure to collect the additional losses. However, if there is a cost to mitigate, that may be collected. Next is punitive damages. These are damages that are used to punish or prevent bad conduct but are rarely used in contract law. However, they can appear, so we wanted to make sure we mentioned them. Reliance is next. Reliance damages are money spent in reliance on the contract before learning of the breach. Once the breach has occurred or notice of the other party's intent to breach, the non-breaching party should refrain from incurring additional expenses. In the case when no contract is actually in place, reliance damages can be ordered through a quasi-contract. Incidental damages. These are expenses that may be incurred by either party resulting from shipping, storage, or even reselling goods following a breach. Nominal damages are those which have no real monetary value but are awarded to the non-breaching party. These awards are typically $1 or some token amount. Consequential damages, which are also called special damages, come from the case Hadley v. Baxendale. This case established that losses that are foreseeable by the non-breaching party may be collected. Additionally, the losses must be actual and the non-breaching party must mitigate damages. Finally, we have expectation damages, which are also referred to as the benefit of the bargain. This award will enable the non-breaching party to pay for the contract services elsewhere. For example, if the contract is for 100 widgets and the breaching party only delivers 90 widgets, the cost to obtain the additional 10 widgets will be subtracted from the payment for the 90 widgets. You may wonder why we presented damages in this order, but it's because we can use a memory device to recall each one. Our mnemonic is LA Prince. L for liquidated damages. A for avoidable consequences. P for punitive. R for reliance. I for incidental. N for nominal, C for consequential, and E for expectation. LA Prince. A secondary grouping you may have heard of is under the category of compensatory damages. These are damages that are designed to put the non-breaching party in the same position prior to the contract being made. These include the expectation, reliance, consequential, and incidental damages, which can be recalled using RICE as a memory device. Reliance, incidental, consequential, and expectation. Now that we have covered legal damages, let's look at equitable remedies. Remedies are specific performance, reformation, and rescission. Specific performance is a court-ordered demand to either do something or to stop doing something. It will be used only when the legal remedy is inadequate. The elements to make a claim for specific performance are 1. An inadequate legal remedy, meaning money won't fix it. 2. Definite contractual terms are in place which can be followed by the court when deciding on the specific performance. 3. The remedy is feasible to enforce. 4. There is mutuality, which means both sides are able to comply. And 5. There are no defenses to the claim. A good mnemonic for these elements are: I'm doing fine, Mom and Dad. The defenses are laches, unclean hands, and the sale having been made to a bona fide purchaser. Recall that a bona fide purchaser is a party that makes a purchase for value who is unaware of any adverse claims. The second equitable remedy is reformation. This is when the courts step in to fix a contract to reflect the true meeting of the minds of the parties. Typically it would be when there has been ambiguity, mistake, misrepresentation, or in some instances when parole evidence has been used to clarify an issue. The third equitable remedy is rescission. This is when the courts allow the contract to be undone and the parties to get out. Some ways this might occur is due to mistake, misrepresentation, or illegal subject matter. Finally, we have quasi-contracts or implied-in-law contracts. These occur when there never was a contract, but in order to avoid unjust enrichment, the courts will proceed as if there had been one in place at the time the benefit was received. Sometimes, you will see reliance here as well when someone detrimentally relies on a contract that never materializes but makes a claim for that money that was spent in anticipation. So there you have it, contract remedies, or, more accurately, contract rights and remedies. Thank you for watching. We hope this helps with your studying. If there are any topics you would like to see, please let us know in the comments below.